We'll go ahead and call Marshall County special call meeting, February 18th, 2020. Appreciate everybody being here. We're going to try to, because of the time limit with our guests, they have to get back to Louisville and Lexington, so we're going to try to do this in a timely manner. But the biggest discussion tonight is the fact that if you look across the state of Kentucky, as of today, there's about 105 counties that have already, in some way or fashion, declared themselves a Second Amendment county. Now, we all know how passionate this issue is, regardless of what side of the coin you're on. But I think what we're going to demonstrate tonight is that when it comes to our constitutional rights, regardless if it's the Second Amendment or any of the amendments, we can't sacrifice them. And it starts with you, the people. So our intent tonight is to sit down, present a resolution, and I think you'll find that what we did is we stepped back and we looked at the bigger picture. We know that there were some pre-filed bills with the General Assembly. To this date, the General Assembly members have stated that some of these bills, if not all of these bills, are not going to make it to committee or not even make it into law, which is good. But that's today. When you look at Virginia, and I will say this, what the biggest difference with Kentucky and Virginia is the Attorney General. You see sitting with us tonight, the Attorney General. Virginia's Attorney General, in my opinion, didn't stand up for the people of Virginia. Didn't stand up for the constitutional rights for those folks. The difference with our Attorney General is he campaigned, he stated when he visited me and the sheriff and the county attorney, he said that he is going to support the Constitution. And he's here tonight to demonstrate that. And I think for us as a community, that shows support, and it gives us a little, if anything, a lot of hope that we still have people who are elected that truly do defend our constitutional rights. And when we read this resolution, you're going to hear the language, and it's going to profoundly state that. And I think it's well written. The biggest thing is there's no bills that have become law to date. And I've asked Mr. Brown to speak on that. There's no pre-filed bills that have been voted on that has become law. So this resolution is just to affirm strongly our Second Amendment right to let our General Assembly know that if unconstitutional laws do come out of the General Assembly, we're not going to accept it. As the counties and our sister counties, we're not going to stand for it. We're going to stand and fight for our rights. And just to make the Attorney General's presence, he's here to support this resolution. An analogy, he'll take the flag and run with it for our counties in this state. And I think that that's profound. This is a model resolution for other counties in this state to use. And I'm excited that we produce this product here in Marshall County. And I think you should be proud of that as well. But I'm not going to take up the airtime. I've asked the Attorney General to be here, and I've asked him to speak to everybody. So, sir.
Well, Judge Neal, I appreciate you, and I appreciate all of the members of the Fiscal Court, and obviously Mr. Brown for the work that you've done and getting this resolution together, and obviously Sheriff McGuire for being such a staunch supporter of the Second Amendment and your responsibility to make sure that the public safety interests of this county are maintained and supported. And want to thank Jason Darnell for the work that you've done on this issue as well. There were so many folks that came to the table to make sure that the rights of you all that are sitting in this room, that the Second Amendment that you hold so dear and so closely is protected. And I'm here as the Attorney General of the Commonwealth of Kentucky to make sure that you all know that I'm going to do everything I possibly can to defend your right to keep and bear arms. There is nothing else more important in my judgment than our amendments to the Bill of Rights, to the Constitution of this country, and to the Constitution here of the Commonwealth of Kentucky. I'm here tonight because Marshall County is important to me. Marshall County is what I would refer to as the backbone of this Commonwealth. So it was important for me to leave Frankfort. I was in the midst of budget conversations in our state's capital today, to come down here to make the trip so that you all know that I am very, very appreciative and honored and proud of the work that's been done as it relates to this resolution. You all have a right to restate and reaffirm your commitment to the Constitution and the Second Amendment. No one should be in the business of taking your arms. I'm here to approve of this resolution that you all have put forth. I'm here to support the resolution that you all have put forth. I'm here to let you know that the Attorney General's office will defend this resolution that you put forth. We've even gone as far, and I just handed a copy of the OAG opinion to Judge Neal to say that we approve of the resolution that you all have, so that there's no mistake about the intent of this resolution, the purpose and goal of this resolution, and that you all should feel comfortable that the Second Amendment rights that you all hold so dear are going to be upheld. So again, I appreciate the opportunity to be with you tonight. It was important for me to get down here because I know that there are so many good men and women and young folks here as well that understand the rights that we have been given in this country and how we have to stand up for them and reaffirm them every day. And I'm grateful for the work that you all have done. So thank you so much for allowing me to attend this evening. And I look forward to hearing what Mr. Brown has to say and other members of the Fiscal Court. But Judge Neal, I really appreciate your leadership on this, and I'm happy to be here.
Thank you, sir. I've asked Kent Masterson Brown to be here to kind of give an overview. Mr. Brown has an extensive background, has been fighting for a long time when it comes to our constitutional rights. So, sir, if you would, please.
Thank you very much, Judge, and members of the Fiscal Court, and all you fine people here from Marshall County, and my good friend, General Cameron. It is a pleasure to be here. My wife and I drove from Lexington, Kentucky this afternoon and got here within a half hour of this starting, and I thought that was pretty daggone good given the time that the length of that trip. But I am very pleased to be here, and pleased for one great reason, and that is, Judge, I support this sort of movement personally. Many people would ask, well, there hasn't been any legislation. Why are you all so worried about this? And indeed, there hasn't been, at least in Kentucky. And because there hasn't been any legislation, no executive order, no rule or regulation promulgated, why are you worried about this? The fact of the matter is that the citizens of the country, of this country, should be concerned about these rights before government starts to act. They should let government know exactly where they stand with respect to the rights embodied in the first 8 amendments to the Constitution, the Bill of Rights. Those are precious. And I'll tell you, of all the amendments to the Constitution, of those 8 amendments, the Second Amendment is probably one of the strongest of all of them in its language. It speaks about a well-regulated militia, but then it says the right of the people to keep and bear arms shall not be infringed. Now, you can't get any stronger than that. And when Justice Antonin Scalia was writing his opinion in the District of Columbia against Heller case that found the ordinance of the District of Columbia, Washington, D.C., that prohibited the ownership of handguns, Scalia went through each one of those phrases, and he put them in quotes in the opinion. The right of the people to keep and bear arms shall not be infringed. He says, how could that be clearer? What do you think the founders intended? They just told you, it shall not be infringed. And I'll tell you, the greatest example we have of rights threatened is what's happened in Virginia. You all been following this? No sooner did one party get a majority in the House and Senate with a governor than the threats came out. Here's what we're going to do to you. They even told people they were going to get more money appropriated for more jails so they could put more citizens in them. Think of that. And do you think they're concerned about these fundamental rights? No, they're not. So what did the citizens of Virginia do? There was no law at the time, no regulation, no statute, no nothing. They went from county to county, independent city to independent city. And they passed resolutions in every one, 104 in Virginia, stating exactly what you've stated here. Hopefully you will stay here. Telling the people in power that we in this county, Rockbridge County, Rockingham County, Frederick County, whatever those counties were, that we would not stand for it. They even went so far as to say the sheriffs in those counties that we're not going to enforce anything. Now, we haven't got there to the point where there's any legislation, nor were those Virginians. But when legislation was reported out of the House and Senate, or introduced into the House and Senate, they came to Richmond by the tens of thousands. And I got to tell you, by the way, 2 days ago, the largest bill that they have proposed, the most important bill, the bill against the semi-automatic weapons, went down in defeat with 3 Democrats voting with the Republicans. And it was defeated. Why? They're scared of the folks, the people. The people have voiced their objections to it, and they're scared to act outside what the people want. So it shows you what happens when you do go on record stating your positions with respect to the Second Amendment or any of these amendments before anything happens. Because it has been had a huge impact in Virginia. Well, I know there's been talk here of passing an ordinance. And as the judge asked me, let me address that. An ordinance is a law that tells people what they can and can't do, and may have a monetary penalty attached to it. May. We're not at that stage at this moment. We haven't seen a bill reported. We haven't seen an executive order. We haven't seen a regulation or a rule come out of any agency. It's the status quo. So when it is that, there's no need to try to say, pass rules about do's and don'ts, because we don't know what we want someone to do or not to do, because we don't have a law that's infringing at this moment. So what you do instead is consider a resolution telling the world what your position is. Now, we have here a resolution that has multiple whereas clauses, all of which contain references to the Second Amendment and what it says, as well as Kentucky's own Section 1, subsection 7 of the Constitution of this state, which protects its citizens in their rights to bear arms. It may be one of the most broad ones ever. And by the way, that's a product of none other than George Mason, the famous revolutionary from Mason's Neck in Virginia. The Second Amendment is James Madison's. That's pretty good company. But we've got not only the Second Amendment, but Kentucky's own Constitution, which we set out in detail. And then we go through a number of different Supreme Court cases, such as one I mentioned about Justice Scalia, the Heller case against the District of Columbia, and then McDonald against the city of Chicago, which was Justice Alito. And he goes through the same exercise with respect to what this amendment says, and then says that, this is a state law, banning the use of handguns. And he says, for the first time, this court is going to examine whether or not the Second Amendment is absorbed into the 14th Amendment for purposes of it being applicable to the states. Because the first 8 amendments go against the federal government. The 14th Amendment disciplines the state. And so does the 14th Amendment include the rights embodied in the Second Amendment? It certainly does for the first. Does it for the second? And what Alito did was say, of course it embodies it. The reason it embodies it is because the right to bear arms is one of the most fundamental and historic rights the citizens of this country have. Fundamental and historic rights that they have. And you know, it's an interesting thing. Look at how the revolution started, the American Revolution, outside of Boston. British troops sent by General Thomas Gage across the Back Bay of Boston on the night of the 18th of April. What were they going to do? They're going to confiscate weapons. And the weapons they wanted to confiscate were being held in Concord. And they get to Lexington, and the militia shows up. And of course, it's a bloodbath. And they move on to Concord, trying to get the weapons. But more and more colonists join the fight from all the surrounding counties out in the hinterlands. And by the time they reach Concord, there are thousands of them, all carrying the arms that were hanging over their mantelpiece. And as Justice Alito says, and Scalia both, that we don't have to look at militia to determine whether or not the right exists in an individual. Those fellas who formed the militia had the guns hanging over their mantelpiece. They were butchers, bakers, candlestick makers, lawyers, doctors, and that's what they did in life. And isn't that the same here? And so when they talk about Scalia and Alito, that this is a fundamental right, they're talking about Lexington and Concord and the result of that. So we go through those cases, and then we say this, that there are threats. There are threats that these rights may be interfered with. may be infringed upon. And we cite the fact that this is happening in Virginia, our mother state, and that it is also, there are also discussions in Frankfurt about enacting measures that may infringe. We don't know. But because of all that, this county resolves to declare itself a Second Amendment and a Section 1.7 of the Kentucky Constitution safe harbor. We don't use the word sanctuary. That's been co-opted by people interested in, well, you know what it is, the sanctuary cities. We don't want that. I like the term safe harbor, because that's what we want people to think this county is, a safe harbor. And that the county acknowledges its responsibility to preserve and protect the constitutional rights of the citizens of the county. And that we understand the misuse of firearms by criminals are because they don't care about the law. And that shouldn't penalize good folks like you. Right? And that we then state that any federal or state statute, executive order, rule, or regulation regarding the right to keep and bear arms that violates the 2nd, 9th, 10th, or 14th Amendments of the Constitution of the United States, or Section 1.7 of the Kentucky Constitution, and or the numerous related Supreme Court decisions that I've outlined for you, including those listed in this matter, shall be regarded by the people of Marshall County to be unconstitutional and a transgression of the supreme law of our nation and state. And that Marshall County does not intend, doesn't say it won't, at this moment, it does not intend to authorize or consent to the use of county funds, resources, employees, agencies, contractors, buildings, detention centers, or offices for purposes of enforcing any measure that is unconstitutional. And that in the event there is the federal or state government by statute, executive order, etc., enacts a measure that undermines the people's rights under the Second Amendment or Section 1.7 of the Kentucky Constitution, it shall consider, in conjunction with other states or alone, proceeding to a court of competent jurisdiction to challenge. And then we then say this, and this is for the benefit of this county, because I know the tragedy that occurred in this county back in, January of 2018. We say this: nothing in this resolution shall be construed to mean or imply that Marshall County does not support or will not enforce all federal and state laws, regulations, and rules regarding the carrying of deadly weapons, whether concealed or not, in government buildings, federal or state, including elementary and secondary schools, or in private establishments that prohibit same. Marshall County will always enforce such laws, regulations, and rules. Folks, that's the resolution. And it's designed to address what may happen. And it's important you get out ahead of an issue like this. 104 different counties in this state have already adopted something similar to this. And I would hope that Marshall County, named for the Chief Justice, John Marshall, would do like this. Thank you all very much.
Thank you, Mr. Brown. One thing that I definitely want to announce is this resolution passes. I plan to submit the resolution with the Attorney General's opinion to the Kentucky Judge Executives Association so that they can push that out to other counties, other judge executives, because this is, in our opinion, this is the model resolution for the state. So that's one thing that I will do. I just want to show also, these are all correspondence to my email. These are emails from folks who, since this has started several months ago, that they actually want action protecting the Second Amendment rights. So I just wanted to show you that there was an outpouring, and I think all of us got this. Somehow they got our email, and people reached out to us, and you would be surprised of how far folks actually reached out to us to show support for this initiative. I know that there was one gentleman who wanted to speak. Do you still want to speak, Dave, or are you good? I can't. You're good? Okay. I know you reached out to me, so I wanted to make sure if you wanted to speak, I'd give you that opportunity. Commissioners, any questions before I read this? Okay. I'm going to go ahead and read the resolution. A resolution of the Marshall County Fiscal Court declaring Marshall County a Second Amendment and a Section 1(7) of the Kentucky Constitution safe harbor. It is the natural tendency of civil government to expand beyond the limits of its rightful constitutional authority and to usurp powers which have not been given to it through the delegated consent of the governed. Whenever the uses of government are perverted and individual sovereignty is overtly endangered or threatened, and all other means of redress are ineffective, the people may, and in fact ought to, force the reestablishment of the original constitutional limits of government. Whereas the Constitution of the United States is supreme law of our nature, or of our nation, and whereas the Second Amendment of the Constitution of the United States provides a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And whereas the Supreme Court of the United States ruled in Miranda versus Arizona, 384 U.S. 436, 1966, that where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. And whereas the Supreme Court of the United States in District of Columbia versus Heller, 554 U.S. 570, 2008, ruled that the Second Amendment right to keep and bear arms is not connected in any way to service in the militia. And whereas the Supreme Court of the United States in United States versus Miller, 307 U.S. 174, 1939, ruled that firearms that are part of ordinary military equipment with use that could contribute to the common defense are protected by the Second Amendment. And whereas the 14th Amendment to the Constitution states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the laws. And whereas the Supreme Court of the United States in McDonald versus the City of Chicago, 561 U.S. 742, 2010, ruled that a person's Second Amendment right to keep and bear arms is further secured by the due process. And the privileges and immunities clauses of the 14th Amendment. This decision also protects rights closely related to the Second Amendment, namely the right to manufacture, transfer, purchase, and sell firearms, accessories, and ammunition. And whereas the 10th Amendment to the Constitution states the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectfully, or to the people. And whereas the Supreme Court of the United States in Prince versus United States, 521 U.S. 898, 1997, ruled that the federal government cannot compel law enforcement officers of the states to enforce federal laws as it would increase the power of the federal government far beyond that which the Constitution intended. And whereas Kentucky's Bill of Rights set forth as Section 1 of the Kentucky Constitution protects the rights of life, liberty, worship, pursuit of safety and happiness, free speech, acquiring and protecting property, peaceable assembly, redress of grievances, and bearing arms. Section 1 of the Kentucky Constitution reads in pertinent part, all men are, by nature, free and equal, and have certain inherent and inalienable rights, among which more may be reckoned. Seventh, the right to bear arms in defense of themselves and of the state, subject to the power of the General Assembly to enact laws to prevent persons from carrying concealed weapons. And whereas the last protectors of the Constitution of the United States are the county sheriffs and we the people. And historically, their ability to fulfill that role successfully rests in part on their Second Amendment rights and the rights set forth in the Section 1.7 of the Kentucky Constitution. Whereas the situation in Virginia, where the governor and members of the General Assembly have announced they will enact statutes restricting the constitutional rights of Virginians to keep and bear arms and threatening the confiscation of arms and jailing those citizens who do not comply therewith is alarming. Now, some members of the Kentucky General Assembly and the governor are publicly advocating laws that might restrict the constitutional rights of the people of Marshall County, Kentucky, to bear arms. Keep and bear arms. Now, therefore, be it resolved by the Fiscal Court of Marshall County, Kentucky as follows. Section 1, the above recitals are true and correct and incorporated in this resolution. Section 2, the people of Marshall County, Kentucky, through their duly elected members of the Fiscal Court and their sheriff, resolve that Marshall County, Kentucky is hereby designated a Second Amendment and a Section 1.7 of Kentucky Constitution safe harbor. Section 3, Marshall County, Kentucky acknowledges its responsibility to protect the people thereof and the right to keep and bear arms by declaring itself a Second Amendment and a Section 1.7 of the Kentucky Constitution safe harbor. Section 4, Marshall County, Kentucky specifically acknowledges the constitutional right, as originally written and understood, to keep and bear arms for self-defense, personal safety, protection of one's family, and in defense of one's community and county. The unalienable right to keep and bear arms, as specified in the Second Amendment to the Constitution of the United States, Section 1.7 of the Kentucky Constitution, and the aforementioned decisions of the Supreme Court of the United States, and the rights to manufacture, transfer, purchase, and sell firearms and ammunition designed for those purposes outlined above, are rights guaranteed by the Second Amendment to the Constitution of the United States and Section 1.7 of the Kentucky Constitution. Section 5, the criminal misuse of firearms is due to the fact that criminals do not obey laws, and that is not a reason to abrogate or abridge the unalienable constitutionally guaranteed rights of law-abiding citizens. Historically, the last protectors of the constitutional rights are we the people, and our ability to fulfill that role successfully rests in part on our Second Amendment rights to the Constitution of the United States and our rights under Section 1.7 of the Kentucky Constitution. Section 6, any federal or state statute, executive order, rule, or regulation regarding the right to keep and bear arms that violates the 2nd, 9th, 10th, or 14th Amendments to the Constitution of the United States, Section 1.7 of the Kentucky Constitution, and/or the numerous related Supreme Court of the United States decisions, including those listed above, shall be regarded by the people of Marshall County to be unconstitutional. A transgression of the supreme law of our nation and state. Section 7, Marshall County, Kentucky, does not intend to authorize or consent to the use of county funds, resources, employees, agencies, contractors, buildings, detention centers, or offices for the purposes of enforcing or assigning in the enforcement of any element of such federal or state statutes, executive orders, rules, or regulations that unconstitutionally infringe on the right of the people to keep and bear arms as described and defined in detail above. Section 8, in the event the federal or state government by statute, executive order, rule, or regulation abridges the rights of the people of Marshall County, Kentucky to keep and bear arms, secured by the Second Amendment of the Constitution of the United States and Section 17 of the Kentucky Constitution, Marshall County will consider alone or in conjunction with its sister counties in Kentucky proceeding to a court of competent jurisdiction to enjoin temporarily and permanently the enforcement thereof, and will consider enacting such ordinances that protect the people of Marshall County, Kentucky, in their exercise of their right to keep and bear arms, secured by the Second Amendment to the Constitution of the United States and Section 17 of the Kentucky Constitution. Section 9, nothing in this resolution shall be construed to mean or imply that Marshall County does not support or will not enforce all federal and state laws, regulations, and rules regarding the carrying of deadly weapons, whether concealed or not, in government buildings, federal or state, including elementary and secondary schools, or in private establishment that prohibit the same. Marshall County will always enforce such laws, regulations, and rules. Section 10, a copy of this resolution shall be spread upon the minutes of this meeting. Section 11, this resolution shall become effective upon adoption. With that, gentlemen, if there's no questions to move forward, we would need an action item to approve this resolution.
I proudly make the motion to adopt this resolution as written.
Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Ladies and gentlemen, I appreciate y'all coming out. I appreciate the effort. I know we've been at this for several months, but I think the court has demonstrated to step back, reach out to those that can support this initiative. I appreciate Attorney General Cameron coming in. Sir, when the sheriff and I met you and talked with you, we wanted to make sure that we had an Attorney General that would fight for the Constitution. Here you are. Thank you. Mr. Brown, thank you for your support and your speech to the citizens here to hear the background of this initiative, and I appreciate that. The Fiscal Court, thank you for supporting this measure, and I'm going to be sending this off to the association so we can get this to the judge executives across the state.
And let me say, too, thank you to our county attorney. I hope the young adults here, if you take, one of the things I would like for you to take from this at least is we as elected officials can disagree with each other and come together and find a solution, just like those of you who may disagree with us as elected officials, and we should be able to come together and come to a solution that is best for all of us. And I think that's all that our county attorney wanted to do this entire time. And unfortunately, I think that got out of hand in my personal opinion. And so I'm glad to see the judge, our county attorney, our attorney general, and Mr. Brown all work together to come to this resolution, so thank you.
All right.
Thank you, Monty. And I also want to thank General Cameron for coming down. He met with us, and when I say us, myself and Dennis Faust, a little bit prior to coming here, and has offered his staunch support to us as we face this trial coming up in June. So thank you very much. And Mr. Brown, it's good to meet you. And
To meet you, too.
thank you for your work on this. And I hope both of y'all have a safe drive back. It's not going to be a fun drive, I can tell you that.
well worth it, well worth it.
Thank you very much.
Thank you.
I appreciate it.
Gentlemen, we just need a motion to adjourn.
So moved.
Second. All those in favor say aye. Aye. Any opposed? Motion carries.